received the party's stipulation regarding how to handle the IGG tip, if you will. I'm fine with that proposed instruction, so that will be given. I think I've asked you also to work on an instruction related to the use of the terms surrounding touch DNA and other variations about that in the event that I decide to correct somebody about the use of that term. As I said, with respect to the professionals in the DNA community itself, I'm not going to prohibit it in the sense that, you know, I'm going to sustain an objection. What I would likely do is to clarify with the jury, if the parties want me to, about that being simply a convenient title and not meaning to imply an actual source of or method of the DNA being present. And so if you haven't worked on that, please do so to get me an instruction you both can live with. Otherwise, I'll end up drafting one myself, and perhaps neither of you want to live with it. So with respect to the model, I think referred to as the dollhouse by Mr. Thompson, has that been produced for the defense to inspect?
As Your Honor, it's actually here in this courthouse, has been for a few weeks, and Mr. Hurwitz facilitated the defense unit yesterday.
Okay.
It's available for the court's inspection well if the court would like to look at it. And just for the record, to the extent that the model was characterized as a dollhouse, I think that's an inappropriate characterization. It is an inappropriate characterization. If I'm responsible for it, I assume responsibility, but that's simply not the appropriate way for it to describe given what occurred there.
I think a better term is simply a model, rough model, given that it is admittedly not to scale precisely. So, Ms. Taylor, any record about that? You had a chance to look at it?
No, we did. We were able to bring 2 experts in for our request yesterday, and we appreciated being accommodated while we were here. We do have a remaining question about where the model house will be stored during the course of the trial.
Where are you storing it, on the 3rd floor? Okay. So it sounds like it's stored with the evidence of the prosecutors down there, and so I suppose if she needs to get access, or our experts do, we can arrange for that as well.
Should have asked a better question, Your Honor. When it's brought in,
that's
the demonstrative aid. I'm curious about when it's not being used by the prosecutor or the defense and a witness, where it will sit in the courtroom.
I will find some place not in the courtroom, because I don't want it in the courtroom when it's not being used, but nearby in the event that a witness does wish to use it. The other thing that I would point out, as it sounds like you've been, at least to some degree, working together, and I appreciate that. As you come to stipulations on things, agreement on things, it's important that those be reduced to writing for your own protection, because too often what I see is in the middle of, for example, trial, well, Your Honor, the other side said that they were going to stipulate to that, and then they're not. That leaves me in a difficult position because I wasn't part of those discussions, right? And so for your own protection, I think it's just important that you get those reduced to writing as much as possible. I did receive the parties' spreadsheets on the exhibits, which we'll go into a little more when we get to the exhibits portion of today's menu. but I appreciate getting that. There's some questions that I had about it generally, and then some more homework to do on it. In terms of the witnesses, I had asked, and I think my law clerk reached out to make sure that we get a description of those witnesses, kind of like if they're who they work for or where they're from, something that will allow me to categorize those on a juror questionnaire so that they don't just get a list of 300 names, but can say, all right, these are witnesses, these people live in Pennsylvania, these are witnesses that work for the FBI, right? And so that they can put in context those names, which will be result in a more accurate review by them of those names to see if they know anybody. And I'm not sure if that's been accomplished yet or not. And so if you haven't done that, please get that to us as soon as possible so we can incorporate those. I think the state had, last I heard, but it's been several days, the defense we were still waiting for someone from the defense.
I believe that that's been provided. My hope was that it was sufficient because I think it came back and we re-provided it.
Okay, I'll check.
If it's not sufficient, let us know.
I'll check on a break to see where it's at. All right. So I did, as I indicated this morning, receive the defense's proffer regarding alternate perpetrators, and that will be sealed per request, I'm assuming per stipulation. And I want some additional information. What I'd like is by the 23rd, if possible, for the defense to do two things. One, provide me with whatever actual evidence you have that supports those allegations, rather than just allegations. And two, provide for me how it is you believe that what you are offering is admissible. Because it seemed to me much of what you had put in there was fairly potentially fairly objectionable in terms of admissibility. So I would like to see that. And then I would have the state respond by the 6th, which is 2 weeks. And then I would propose a hearing on the 18th.